Now we'll give the floor to our expert reviewer. We will only have one at this point. He will be given full 10 minutes to give his comments. I'd like to give now the microphone to Pahadi Rahmat Purnama. Your 10 minutes, and then after that, Enrico, you're given 5 minutes again to answer any of his inquiries or to give comments to his comments. Thank you.
Okay, thank you, Joel. It's a very excellent presentations given by Enrico, and also I think it's very interesting issues that you wrote in these articles. My comments is first, there is some, I don't know, maybe typo in the beginning of this your articles, as I read it, when you mentioned about Angola and then suddenly you say Indonesia. I think it's supposed to be Angola, right? And where is it? Let me check. Yeah, in the when you mentioned about when you trying to explain the article 1 paragraph 1, you took when you explaining about like products, and then you take examples of Angola, especially on the milk from cow. I think it's supposed to be, this will be considered as discriminations if in fact the cows that live in France located in the area within 1,500 meters altitude with the highest point in Indonesia. It's supposed to be Angola, right? Or yeah. So that's just a little bit typo. But considering the issues that you are working, the one that you are writing here, it's very interesting in terms of the most favored nations, and then this is the case is still in the process of establishment of panel. If I look at the WTO website, so it hasn't been going to the panel yet, still establishing the panel. And then I think it's also very interesting if you look at this also from the little bit different point of view, because some of the examples that you are giving, especially when you talk about most favored nations, is most likely is supposed to be between the EU and outside of the EU member. But some of your examples regarding the issue of the discriminations, you compare within EU member and Indonesia, because Indonesia outside of EU member. So it's most likely to discriminations under national treatment on the article on article 3, yeah. So when you compare the membership of European Unions, because European Unions is the free trade area, they have the so-called custom unions, which is exceptions from the article 24, yeah, Banyu ya? 24. So article 24 give exceptions for this free trade area, so-called custom unions, to have different preferentials to the members of the European Union compared to the outside of the European Union. So by comparing between the European Union member and Indonesia, it's not comparable. So if you want to compare is with the other palm oil producers, such as, for example, Malaysia, which is not the European Union's member. So that's we can see the difference between most favored nations between outside of EU member. So when we talk about discriminations between the EU member and outside of EU member, it's more like national treatment issues rather than most favored nation. So what you are doing, I think it's already very interesting. And then the other issue is, I think when we talk about the most favored nations, I think you need to go a little bit in depth to what kind of discriminations that existed. For example, in the original cases, there is issues of technical barrier to trade on TBT, yeah, and also there is issue of subsidies and countervailing measures. So these two issues might become something that you need to consider to put into your article to see how the discriminations existed in terms of most favored nation, because the most favored nations in the GATT 1994 is very general. So we need to look at more on specific actions of the European member in order the reader to see what kind of actions that being discriminated, because the red 2, yeah, which is considered to be discriminations, it has to be linked or have the relation to certain issues, whether the TBT or SCM, yeah, subsidies and countervailing measures. So to see more clear what kind of discriminations that you're looking at. It's okay if you want to see most favored nations issue in more general term, but as a reader, what I need is what is the actions can be considered into the WTO law. So that one of my one of my comments. And then the third comment is that I think that's quite a lot of writers that looking at the most favored nations. So what you need to do is how you differentiate the issues that you are going to look at or you are going to deliver in your articles. So because when you talk about most favored nation, it's, as I mentioned before, it's very general. Yeah, in order to make more interesting to the reader, so the reader can see what is your issue different from other than the case is itself, because the case is, but most favored nation is quite a lot in WTO, because that's most likely the cases brought to WTO is based on discrimination and most favored nation. So you have to maybe a little bit specify what kind of most favored nations, yeah, what is your you have to, yeah, like you can look at or you can have the uniqueness or something that different from other writers in giving this issue of most favored nations. I think in terms of other things, the structures and the analysis, it's quite good. And then I think it's good to have this kind of publications in the Indonesia Law Review, especially for the reader to know more about the issue in general, on the most favored nations, the GATT, and WTO, and specifically about the case on the palm oil. I think that might one more thing. Maybe you can look little bit more about the ILUC, yeah, in order to make more interesting about your articles. I think that's from my end. Thank you.
Thank you very much. And again, Pa Enrico, you're given 5 minutes. I hope that you don't feel bad about the comments. I think they're quite helpful and constructive. You're given 5 minutes to answer any of the inquiries that were raised.
Okay, thank you very much from the comment from Pak Hadi. It is my pleasure and honor to receive the comments and the feedbacks from the reviewer. So I think for the typos in the articles, yes, it is should be Angola and French, not Indonesia. So I will revise those articles. And about your comment about how we can improve this article. So basically, like you said that yes, I only discuss about MFN obligations, not touch about the SCM or TBT to make the focus of this article only in MFN. But your inputs are really valuable, because yeah, TBT also in the real case also become the topic of this discussion. So yeah, I will touch a little bit about this issue for the TBT as well, so we can make this article more relevant and make sense. So about the MFN and national treatment, so yeah, I think the discrimination itself, I will make it more clearly in this article. But I think the discrimination itself, it's about, for my perspective, it's about palm oil itself as a product and non-palm oil such as rapeseed and soybean with the classifications of high ILUC. So there was import restrictions, and also there was a trade advantage provided to non-palm oil. That's what the discriminations occurs. And as you can see, that the palm oil is not produced in the AU. That's why the non-AU members will be impacted by this policy from RED 2, because there will be freezing and phase out for the palm oil, and then there will no advantage provided to AU members. So that's I think the discrimination from this policy from RED 2. But I will make it more clearly and also touch about TBT. That's why I would like to thank Pak Hadi for your inputs, and also look at your last input about ILUC. Look at ILUC to make this article more interesting. Yep, I will improve a little bit my article to mention about ILUC. So in order to make this article more interesting, I will also cover this area about the ILUC. Okay, thank you. I hope my comment already cover to all your inputs, Pak Hadi.
Thank you, Mr. Enrico. Do you want to thank anyone who has helped you with the paper? Maybe it's your chance to, before we get to the next paper. Do you want to thank your advisor? Anyone?
Thank you very much. So first of all, I would like to thank to my lecturers in University of Dundee who taught about WTO law, Dr. Sufyan Durobi, because without him, I will not get insight about this WTO, especially about MFN also, and also he provide input to my article, and also some insights to my article to become more readable to the audience, and also to the reviewer, and also to the staff in University of Indonesia, especially for ILREF journal. Thank you for having me, and thank you for the comments, especially from Pak Hadi, so I can improve my article to become more readable and more useful for the audience in Indonesia and also to other international readers, and also to all the committee, to the Master of Ceremony as well. Thank you for having me and preparing all this event. I wish all the best for ILREF and also to this event going forward. Thank you.
Thank you very much, Mr. Enrico. We know it's quite early in the UK. It's 7 hours. You're 7 hours behind. Thank you very much. Hope you can have a wonderful breakfast after this. I believe, will he be receiving a copy of this video, Ka? Will he be receiving a copy of this video, no?
Yeah, we can.
So that they can review the comments. Thank you very much, Enrico.
Thank you. Thank you.
Good luck.
Bye-bye.
Bye-bye.
And if you want to stay, it's okay.
Yes, if you want to stay, and yeah, while having your breakfast. What time is it there now?
Yeah, it's okay.
Okay, sure,
Yes?
sure. I will.
Okay.
I will stay.
Thank you. Terima kasih. All right. So for the next paper, we have Adiwarman. Adiwarman from Universitas Indonesia, who will join us on site. Yes. His paper is about liability rule practices amidst the property rule of Indonesian capital market. Wow. All right. So you will have 15 minutes to present, and then your reviewers are Dr. Paramita Chayangnintias. Is she here? She's online.
I'm
And then-
here.
Hello.
And you pronounce my name wrong.
We miss you here. Thank you very much, Dr. Paramita and Dr. Yeti Komalsari Dewi. We will join us here. Okay, later. Okay. So, Mr. Adiwarman, the floor is yours. You want to sit down?
Bismillahirrahmanirrahim. Thank you very much, Mr. Joe, and all audience. This is the first time that I have to present my paper. It is still, I think it is still needs to improve. So this is the best chance for me to be here to present my paper. My paper titled Liability Rule Practices Amidst the Property Rule. This is not the sole phenomenon in capital market, but it is a general phenomenon in other areas. But in capital markets, conflict of interest transaction is the one of most influential transaction to the independent shareholders. I take one image from the San Diego University to describe conflict of interest, and then I think this is I want to describe about the backgrounds. Back to the 1960s, Berle and Means wrote a theory called agency problem. It means there is a gap. There was a gap between shareholders and directors in decision-making process in company. So in this situation, directors have more power and access to the information and process decision-making process. And then to overcome the gap, there is a disclosure principle for the material transaction. It means every listed company should tell the public every corporate material action. And then agency problems is connected to the concentration ownership. That's mean the structure of ownership is in the one of shareholders, and the others will be the minority or independent shareholders. Transaction, conflict of interest transaction could lead to corporate incentive or corporate profits vis-a-vis directors majority shareholder incentive. The main problem is how does Indonesia enforce the rule of 9E1, and it is converted to Peraturan OJK number 52 2020, but the substance is the same. Next slide. The methods I use: normative method, literature review, and secondary data. It is a theoretical perspective to analyze the problems. I use theory of collaboration Melamed property rule. They state that property rules rights are a main concept that have implications for procedures. Transactions that occur between owners and buyers of objects that contain conflicts of interest are voluntary. The owner of the object of the conflict interest transaction has the right to determine the value. Decision regarding conflict of interest transaction are collective decision. This is the theoretical perspective of property rule. And then about liability, when the bargaining is impossible, a liability rule will result in inefficient behavior. If the negligent injurers must pay equal the harm their ex produce, for injurers will then take action if and only if the value of their activity exceeds the harm it causes. Conflict interest consists of give and or get loan, acquire, dispose of, or use asset, including in order to guarantee, acquire, dispose, or use the services or securities of company or a control company. Enter into a contract in connection with the activities are referred to an item 1, item 2, and item 3, which are carried out in one transaction or in series of transactions for specific purpose of or activities. Findings: conflict of interest transaction occur often in Indonesia. Until now, I find the latest alleged conflict of interest transaction is the merger of GoTo. Listed company did conflict interest upon business opportunity, reason, and it contribute the wealth of listed company. But in fact, there are many conflict of interest transaction without independent shareholders approval. This is the main point that conflict of interest occur in Indonesia. Every action or decision taken by the listed company without approval from independent shareholder will be compensated. If it is returned to the purpose of establishing the company, then main purpose of managing the company is to make a profit. Conflict of interest transactions are taken place without approval of independent shareholders, then it violates to the company's objective, but the violation is considered reasonable and still in accordance with the company's objective. And I try to make several recommendations. I think OJK amends the regulation relating to approval independent shareholders. If the transaction does not harm to the company, then the approval can be replaced by notification or delivery information. The second, if the conflict interest cause a loss, then OJK does not stop at enforcing the provision regarding the conflict interest transaction rule, but should also include the implementation of liability rule, compensation to shareholders. And then the fairness of conflict interest transaction is the determinant of the validity of the transaction. Profit and loss analysis and market price can be applied to assess the fairness of the conflict interest transaction. And the last, the court become a forum to determine the value of compensation for conflict interest transaction and that are detrimental to the company. I think this is the end of my presentation. Thank you very much.
Thank you, Mas. Thank you, Pak.
Thank you.
Pak Adi? Yeah. Masih ada waktu tak? Sorry. Yes. You have anything else to say? Nothing. All right. So we will give 15 minutes now to your commenters, and then you'll be given 5 to 10 minutes to comment on your to respond on to their comments. All right.
Okay.
So can we call on Dr. Paramita?
Okay, thank you. And please tell me again who is the name of the presenter.
Adi Warman.
Okay. Good afternoon, Bapak Adi Warman. Good afternoon, moderator and the audience at Hotel Kumaya. First of all, I would like to apologize that I cannot join the conference on site. I hope it will be okay. And thank you for giving me the opportunity to join the very prestigious conference that held by Universitas Indonesia College of Faculty of Law. This paper idea is very good. Very interesting to write a paper to do a research on Indonesia capital market. Indonesia capital market is a very ancient institution. And the Indonesia capital market law is also a very old regulation that need to be amended soon. But fortunately, Indonesian capital market law still sufficient enough to regulate the capital market operation. With the activity of the OJK, with many regulation by OJK, it can control, it can give protection for every parties in the capital market transaction. First of all, Bapak Adi Warman, your paper title is quite bombastic, but the title is not in line with what you write in the paper. Maybe you should give us more detail on what do you mean about the property rule of Indonesian capital market. In which part of any regulation ever mention about the property rule, or what approach that are Indonesia capital market supposed to use to recognize property rule into the capital market law? Okay, because your paper actually talking a lot about very interesting things such as transparency, such as fair position for many parties in the capital market transaction. Good title, very interesting title, should replace your old title. That new title will bring us, the audience, the one who is going to read your paper, into understanding, oh, this is what Adewarman want to tell us about Indonesia capital market, about the rights of the independent shareholders, about the liability of the directors towards the independent shareholders, towards what should the regulator on capital market should do. Okay. Second, besides the title, is the organization of the paper. You should organize your paper more compact. It is too broad, too long. Okay, because it's the content of the paper is too broad and too long, we sometimes lose the grasp about what are you going to tell us. What is exactly the core of this paper? Because Mas Adewarman must tell us many things, telling us about this too deep, telling us about this too deep. Then you forget to tell us about what is the core thing about your paper. The most important thing besides those are there are still many bahasa Indonesia that you forgot to translate into English. Maybe Mas Adewarman should read it carefully from page 1 to the last and make a recheck for the paper. Can you tell me how do you do this research, sir? Moderator, can Mr. Adewarman answer my question?
Thank you, Mr. Dr. Paramita. Yes.
Just call me Bumita. Okay.
Paramita.
Yeah, Bumita, Pak.
Bumita. Thank you very much. Yeah, I think it is about my theoretical concern, and that I understand that regulation of conflict of interest transaction rule in Indonesia is influenced by the property rule. It's mean before the transaction is done, the company should have approval from independent shareholders. But in reality, there are so many conflict of interest transaction, just did without approval from the independent shareholders. It means it's followed the Peraturan OJK number 42, the latest rule, but the previous rule is the same, and I found from the 2000 until now, in every year there always a conflict of interest transaction is done by the listed company. And then I'm very thankful for the critics about my writing structures, about my structure of my paper, and I will be use this comment, Dr. Paramita, Dr. Mita, to improve to make my paper will focus more focus, and not too broad and too long about the many things. And then I try to mention about the parties in the transaction in order to make a wholly comprehension about the transaction.
Okay, Mas Dharma, Adewarman, I think at first you should restructure your title, sir. Your title should show who is the subject? So who should have the liability to taking care of the property rule to avoid conflict of interest, to protect, to give information for the independent shareholder. So, in my opinion, the director should be mentioned in the title. To avoid conflict of interest should also appear in the title. And I haven't seen the issue of this paper actually. I just found a sentence that declaring that this paper actually want to say something about this, but it is not clear. Was it an issue, the issue of this paper or not? So you should also declare clearly what is the issue of this paper. Itu Mas.
Okay, I will.
Sorry, we will. Bu, do you have any more comments?
Yes, I already give many comments.
Thank you so much, Bu. We will give
Thank you.
give Pa Adi the time to comment. We will just wait for the other. You have one more. Do you have time to breathe? Do you want some coffee? Okay. Thank you so much, Bu Paramita. Pamita.
You're welcome very much.
Please join us. Don't leave us. We have another expert. Oh, she will join us later. So, okay. Do you want to comment now? Or so what is this? Okay. Bu, we will first put a break on this paper. Because the other expert has yet to arrive in Semarang. Is she?
Oh.
No. She's in Semarang.
Another parallel session.
Oh, she's in another parallel session, so she cannot break herself into two. We will have to put a break on this paper. Mas Adi, do you mind waiting for a bit more? Okay. He doesn't mind. Thank you very much.
Okay.
Okay, so now we will go. Yes, please, can you please give a round of applause for our commenters? All right. Now we will be the third paper. Yes, sure. Okay, now I would like to give now the platform to Ms. Fadia, who will be taking on the moderation of the next session. Please give a round of applause.
Okay, ladies and gentlemen, both online and online. May I introduce you? My name is Fadia, and I am the second moderator for today's forum at Indonesia Law Review 6th Law Scholars Writing Colloquium held in Semarang. And after the second paper, we'll have the third paper. The paper has titled An Analytical Study on the Ascendancy of the Legislator over the Constitutional Court in Indonesia compared to developed countries. This paper is written by Muhammad Arif Agus and Andi Irfan Alamsyah from Hasanuddin University, Makassar. And the author, Mr. Muhammad Arif Agus, is on site. We have him here. And the second author, Mr. Andi Irfan Alamsyah, is gonna join us online. Okay, so to the authors. The floor is yours.
I check my PC first. Check. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. First of all, we want to say thank you very much for the commit was invite us to join in this event. And secondly, I want to say express our grateful and our honor to the panelists who has also joined in this session. Let us presenting our paper with the topic about an analytical study on the ascendancy of the legislature over the constitutional court in Indonesia compared to developed countries. And with this topic, to analyze this topic, we have a team. The next slide. Me as Andi Muhammad Irfan Alamsyah, and also I have my friends. He should join also in this session, but because the rundown is fast than we share before, so he will not join maybe. The first part of our article is about the introduction. The next slide. Maybe I can stand up to improve my presentation. Thank you very much for your attention. We know today the dismissal of judge of the Constitutional Court by DPR has led to various response. Some legal expert and also former judge of Constitutional Court do not agree with this because it is against the law and violates the principal independence of judicial power. And the polemic of dismissal of judge of the Constitutional Court by DPR as a legislative body with the Constitutional Court, to the Constitutional Court, we can analyze by two principles. We can analyze with the perspective the configuration of two principles. The first principle is check and balances, and the second principle is about the judicial independence of Constitutional Court. What we wanna get in this paper, with the studies of this paper is expected to be an additional literature in the formulating of policies, especially related to the ideal form of legislative power relation with the Constitutional Court in Indonesia in the future. And the next slide. The next slide maybe. Also, we want to present our research method. Our research method that we are using in this paper is, the first is normative judicial, or we are also called the legal research. With this form, we analyze legal rules, especially the formal regulation or other regulation related in this topic. And we also using a secondary data. The first is about a book, literature, magazine, or another academic writing that we got in the internet. And also we are using a comparative study to sharp our study related to this topic. We also compare this system in Indonesia with the several developed countries regarding the power of legislature and the Constitutional Court. The next slide, please. The first part of this paper is about independency in the check and balances framework. We know in our Constitution of Republic Indonesia, this constitution regulates the principle of check and balances between state institutions. But in other hand, also recognition the principle of judicial independence. the arrangement of check and balances, besides being a derivative of the concept of separation of power, it's also a form to effort to maintain a balance of authority between each institution, especially executive, legislative, and judicial. And in the other hand, the principle of judicial independence is an absolute principle to be applied in the country that adheres to the concept of rule of law. The point that we get at this part is, based on the various theories described, we conclude that the concept of check and balances and judicial independence is a concept that must always go hand in hand. The orientation of implementing check and balances between states and institutions in order to provide limits and control over the use of their authority, on the other hand, also requires a position of judicial independence. The judiciary is the upstream of the law enforcement process, including legal cases that also involve the interests of each state's institution. In short, we conclude that the existence of the principle of check and balances also requires the judge to work independently. The next slide. The second part of our paper about the independence of the Constitutional Court. We know, based on the history, the establishment of Constitutional Court cannot be separated from the development of law and state administration regarding the testing of legal product by judicial institution, or what is known as a judicial review. Through the Constitutional Court decision related to the judicial review, we create a control mechanism to the law-making authority by the President and DPR. The point that we want to conclude that at this part is about, as a part of one of the judicial institution that exercise judicial power, the Constitutional Court is actually bound by the principle of independence in carrying out its duties. The Constitutional Court is required to be free for all forms of intervention. But the main point, however, the regulation of independence of Constitutional Court does not necessarily make the court free from relation or influence from other power, especially the DPR in our country as a representation of legislative power. The next slide. So we are going to the part C about the intervention of DPR to the Constitutional Court in Indonesia. The first, we find there are two forms relation. The first is about relation about to propose the constitutional judge. We know in our constitution regulates that DPR have authority to propose 3 judges in the Constitutional Court. But the point that we need to say that also the Constitutional Court judge in their requirement process involve a separate process proposing institution, it doesn't mean that the representative from each of these institutions will intervene in the existence of Constitutional Court. After being appointed as a constitutional judge, every constitutional judge must present himself as a judge of Constitutional Court who is no longer influenced by the election mechanism from where and by whom. And the next slide. And the second form is about the authority to make laws whose substance regulate the Constitutional Court. We know in Article 20 in our Constitution of Republic Indonesia, DPR have a power to make laws. And each draft laws is discussed by the House Representative or DPR and the President for mutual approval. We see in the period of 2003 until 2020, there are some dynamics amendment with the Constitutional Court regulation. There have been 3 times amendment regulation regarding the Constitutional Court, and now the issue is will go to the fourth amendment. The point that we say, that we conclude that at this part is, in the law concept of drafting laws is in Indonesia, especially laws governing judicial institution, there is no limit to the legislative power in regulating and formulating norms that may conflict with the principle of independence of judicial power. This is different when we compare some countries where the amendment of the law in the field of judicial powers recognize the limits of what the legislature can and cannot do in regulating judicial institution. This part is present by my friend, but because he joined.
I'm here.
Oh, okay. The next part will continue by my friend Muhammad Arif Agus. Time's yours.
Well, honorable panelists, today I'm here to explain about the party comparative analysis on the existence of the legislature ascendancy over the constitutional court between Indonesia and developed countries in various aspects. Well, next. Okay, so first of all, we need to understand that I explained there are two kinds of relation. First is usual relationship, and the second is ascendancy. A relationship is a bond between two same level powers, and ascendancy a power to intervene other power. Next, the strong relationship between legislature and constitutional court in Indonesia will be formed into three points. The first is the fulfillment that DPR as one of in clash with the other institutions. And the third one is the power to configure the laws. DPR has a right to establish the laws regarding the constitutional court. And the third one is the crucial point, which is DPR has a strong power to intervene any regulations about constitutional court, even if there is a judicial view. And then next, so an urgency comes to compare the condition of Indonesia with the relationship between legislature and constitutional court in developed countries. Why? First of all, we know that developed countries in advance exercising any aspect of the nation, such as economy, health, and including laws. And we found that there are various types of legislature interventions to the constitutional court in developed countries. And because these various types of interventions, there will be possibility of political interest play in legislature intervention to the constitutional court. Next. So, there will be the major point of our paper that there are 6 crucial aspects that need to be analyzed in terms of the ascendancy of the legislature over the constitutional court. So there are 6 points displayed in the screen, and I will begin with the first point. Next. The first point is about the appointment of judges. In Indonesia, DPR has jurisdiction to fulfill 3 positions by proposing individual to president. But in other hand, Germany and China also include the House of Representatives, and also in Russia, similarly with the Indonesia. So, but the major point in here is that no place for a legislature to directly appoint justice in UK and USA. So we present that UK and USA will be different to the other countries. And next, as our partial conclusion that several developed countries giving the ascendancy to the legislature often over the appointment. But there are countries that not giving any rights for the legislature to appoint the judges. Next. The second point is about the requirement of judges. We know Indonesia has regulation that will be strict regulation to the candidate. But we know that in Japan, for example, of developed countries, they have broadly regulation about who can be candidate of the constitutional judge, or I mean the Supreme Court judge. So in Japan has possibility in which lawyer or professor in total of 10 years, they can be including as a candidate of the Supreme Court judge. So it will be more broadly than the Indonesia. Next. So our conclusion in here that the range of ascendancy of the legislature over the judge depends on how broadly the requirement reach the candidates. As a gate, the bigger size open the wider access to a large amount of people and political intentions that might be involved. Next. The third of all is the ascendancy of the legislature over the selection of chief judges. Well, in Indonesia, there will be a meeting that chaired by the oldest constitutional court justice. Therefore, there is no place for the legislature to be involved in here. In developed countries, also similar with Indonesia. In US, Japan, and India, there are no place for the legislature to intervene or to participate in the selection of chief judges. Next. So will we conclude that independency of highest level court is well protected in developed countries and also in Indonesia. It brings us to the conclusion that the ascendancy of legislature over the appointment of chief justice does not exist. Next. The fourth point is that the number of judges fulfillment. There will be 9 number of judges in Indonesia, and it's based on the power of executive, legislative, and also judicial. There will be 3 for those power to select any candidate for constitutional court. And different with developed countries such as Canada, in here, there will be no separation of power, but they separate the number of judges by the traditional form or by the place or province. So, for example, there will be 3 judges from Ontario, Western Canada, 2 of judges, and there will be different amount of judges in any province of Canada. But in Japan, there will be 14 justices appointed by emperor and recommended by the cabinet. In here, we will be get a conclusion like next. There will be a power of executive. The executive organs or executive power will be have an important role to elect the number of judges. Differently with Indonesia giving opportunity to fulfill the number of judges. Next. The fifth point is that about the period of justice. In the past, Indonesia chose short-term period, which is 5 years, acknowledged as the symbol of political election in Indonesia. But in here, after the revision, 15 years period or maximum age of 70 years old for each candidate of constitutional court. With comparison with the developed countries, they give proper length of period to the judges. For example, in Canada, there will be 75 years old, and in Italy, 12 years of period. Next. So, our partial conclusion for the fifth point is that a longer period of justice will strictly protect the independency of judges rather than short-term period. Most of previous developed countries explained before are not giving any significant role to the legislature since the period of justice stated in the laws regarding constitution. However, there will be possibility of intervention by the DPR or the legislature revise the relevant laws. Next, the last point of today is the impeachment of justice. And this will be the most crucial point, which can cut off the period of justice. For example, in Indonesia, the unique case of Professor Aswanto will be a big challenge for Indonesia. If Professor Aswanto from the office, there will be a significant change in terms of the ascendancy of the legislature over the Constitutional Court.
Yeah.
Differently
Sorry, Mr.
with
Arif.
developed countries in US,
Sorry, Mr.
UK, India, and Japan, they have no place to impeach any justice. Even the effort is exists, but there will be no successful impeachment. Next, last slide. So the point in the sixth point is that the protection of the justice independency and integrity prioritized in the developed countries. In other hand, Indonesia has certain regulation, but the legislature tried to violate the law. Next. Okay, so we will come to final conclusion. First of all, we want to say that the final conclusion should emphasize that in specific aspect, a relation turns into ascendancy of the legislature over the Constitutional Court or Supreme Court. And second of all, the independency of Constitutional Court justice strictly protected among developed countries in various aspects. And third of all is the ascendancy over the court existed in Indonesia. Unfortunately, it experienced a new form of ascendancy over Constitutional Court by removal of the Honorable Judge Prof. Aswanto. If in the future President will decree officially the Honorable Judge of Professor Aswanto, there will be a point that the ascendancy in Indonesia is really exist over the Constitutional Court. Thank you for the opportunity. This is the end of our presentation. Thank you.
Thank you. Thank you so much for the presenters, Mr. Arif and Mr. Irfan. That's a very detailed presentations. And now we have our reviewers for the third paper. So I call Bapak Dr. Ibnu Sina Chandra Negara and Ibu Dr. Kurota Ayuni, who are joining us online. So for the first time, I will give the floor to Bapak Dr. Ibnu Sina Chandra Negara. Please, Bapak Ibnu. Yes.
Okay, thank you for the Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. I would like to say thanks for the invitations to review the papers. I would send my respect to Joko Sutomo Research Center, Faculty of Law, the University of Indonesia. And I would like to say thanks to all professor and participants who joined in this event. So I have some notes on the paper that sent to me that I have to creating notes and review. And the article has a title, an analytical study on the ascendancy of legislatures over the Constitutional Court Indonesia compared to developed countries. According to the review forms that I already sent to the committee, I already sent my review results, all analysis through the emails. I would like to present my notes. Yeah, my notes on review results in 4 aspects. The first is review on introductions, review on result and discussion, review on the case, and the final is review on the conclusions. For the first points, on the review on intro sections, I have 2 things that the author need to take concern and take attention. Is I have a focus study on judicial independence. So I'm concerned about the topic, and I'm happy with these issues, that the sense of urgency this issue need to discuss, and the authors has creating good and nice topics. But I have some notes to tell to the authors. The first one is the focus on the terminology that the author used on these papers. The first is the use of an ascendancy in this article. When I read the article, it's often presented differently from the judicial interventions, but tends to have the same meaning. Even I already listened to the presentations, what the ascendancy means by the authors, but in the articles and the papers, seems like there is have a different meaning with judicial interventions. The common terminology on judicial independence or judicial accountability articles, that judicial intervention have specific doctrines, but the papers tend to have the same meaning. So there is two questions about that. Is it really like that? The author means to do that. If it's what is meant to be different, then what is the difference? Because if we look on the literature that use the ascendancy in the judiciary terms, is quite rare. Yeah. If we don't want to say rare. Yeah. There are only one book that I already know that antecedents can connect it with the judiciary, is the book of Jackson B. Ojang. He is from Kenya. His book is Antecedent Judiciary in East Africa, reconfiguring the balance of power in the democratizing constitutional order in 2013. But the Antecedent Judiciary in East Africa that Ojang has wrote, unfortunately, he said that the antecedent of judiciary tends to be the same as the meaning of juristocracy, as Professor Bella Kokol, and in his news book about juristocracy 2021 has released the books, and it is same meaning about the antecedents of judiciary to juristocracy. So the antecedency is how the court try to intervene the legislators. So it is different things that, but maybe the author has their own perspective. So I notes on the review intro how the terminology of the antecedency are used, something like that. For the second point that I would like to review is the focus on judicial independence and check and balances aspect that would like to focus on, because in some literature we can say that there is only two. If you want to make it simple, there is only two kind of independence. The first one is an institutional independence for judiciary, and the second is personal independence. So according to the case and according to the big issues that the author want to expand and want to describe, it's quite big. I guess that the author would like to focus on institutional aspect, but when I read more, it's on the personal independence of the judges. So this is the thing that I would like to tell, that the author need to be focused what kind of independency of judiciary that they need, the author need to be focused here. Because if they want to use institutional and personal independence, this topic need to be expand the issues, not only in the case of Justice Aswanto, and it is related to the doctrine of tyranny of legislator act here over the judiciary, but the main problem is the case focus on the Justice Aswanto impeachment. But in this case too, I have some question about why the author using impeachment. Why not using the term of recall if we know the history or the focus on the case, yeah, as I'm start to move to the third point on my review. In my point of view, in my perspective, the case is about the recall of Justice Aswanto, not impeach of Justice Aswanto. And in our legal system, there is no some specific mechanism for impeachment of constitutional justice. So I think the author need to describe it. I can suggest that the author can describe more profoundly about this case. Is it impeachment or recalling mechanism? And I think the author can creating a more descriptive story behind the case about the letter from the Secretary of General or the Constitutional Court decisions behind the story of the case, or the author can connect it to the doctrines about judicial independence. Is it active interventions or passive interventions? Because this is the main problem. But in my opinions, but the case, the author need to be more complete and profoundly to expand more on this story, because I see that is it not impeachment, but seems like it's recalling cases on justice of Constitutional Court. And then my final notes on the papers is I see there is a jumping on the conclusions, jumping idea, jumping analysis, because I don't know is it the maximum of the pages that the author to read, or there's a deadline that the author need to finish the conclusion. But I see that there's a plot hole or some hole on some questions that the author do not answer, such as how about the relation between the comparative studies, the comparative studies, that what is the urgency of comparative studies used on these articles, and is any the states that use for the object of the comparative studies are there a mechanism of impeachment of the justice or recall, because this is two things the difference, and there are two variables that that stated on the research question that need to be answered. The first one is the legal standing. The author notes the legal standing is to be the main focus and need to be answered, and the final variables that, or the final research question on the paper that the authors do not finish the answer is what's the impact, the benefits, or the significant impact from the comparative studies to the case that creating relation between the House and the Indonesian court, especially on the judiciary. Unfortunately, I guess these two research questions not yet concluded in these sections. So this is my final notes. I hope this will be helping the author creating the better manuscript, and I'm happy to read, and I'm very thankful for all the organizers that contacting me to review this nice paper. I will close my opinion. Billahi bisabil haq, fastabiqul khairat. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you so much for Dr. Ibnu Sina Chandra Negara. That's a very valuable and very insightful and comprehensive feedbacks for the authors. And to make it more comprehensive, let us hear or listen to the second reviewers for this paper. We are gonna listen the review from Ibu Dr. Kurota Ayuni. Ibu Dr. Kurota Ayuni, the floor is yours.
Okay, thank you very much for the opportunity. It is honor for me to join this colloquium, and I have read the paper from the authors, and then there's also some question for the authors. The first of all is the issue about Aswanto and the mechanism of recall. Maybe some people call it recall in the Constitutional Court, and then come from the DPR. Is actually not yet successful, yeah. So it's still a political maneuver. The question is, if you state that this is normative juridical, how you mention those political into a reality? Because until now, I see no response from the president, and then the Constitutional Court is still run their business as usual. So I don't think this paper has captured the issues clearly, because the paper was standing in the belief that Aswanto already impeached or already recalled. That's the first thing. The second thing is your statement about the power in the parliament has attacking or have an ascendancy to the Constitutional Court is not yet proved. In many of issues, the new law, the proposed new law about a draft on the amendment of the Constitutional Court law has put one idea on an Article 48, if I'm not mistaken, on that kind of recalling. But it's still a debate, and then it's still not yet becoming a regulation. So in the question of normative and juridical legal aspect, as your method mentioned in the paper, I'm questioning what is the norma, and then what is the characteristic that you mentioned about das Sollen and das Sein, and what is the real question on those reality and phenomena. That's my first question. And then also there's a lot of debates on this aspect in this paper, because you always point out on the parliament. You also mention about there is 9 judges and 3 judges is choose by DPR, 3 other judges choose by by the president, and then 3 other judges choose from the Supreme Court. But the paper has unbalanced views on how the parliament will override the Constitutional Court, while you also mentioned there is also three institutions that involve in the appointment of the judges. So it kind of imbalance analysis, what I've read, and sometimes this imbalance create a false ending and false ending when I read it. So for international readers, this paper might create a misunderstanding about how Indonesia create check and balances and independence in judiciary. The question would be for the author is, you need to make whole concept on how Indonesia run in the appointment of judges, and very carefully mention about the DPR. The reality today is not happen, it is not reflect in any law. It's only a political maneuver, and it's not yet proven. Even though the other case in Croatia in 2007 also impeached their judges in the Constitutional Court, which is a very good reflection if you want to take apple to apple comparison. But the case is very different in Indonesia today, because in Indonesia there is no success maneuver. The third one is beside of imbalance of views. I think many of the concept is not carefully taking in the very careful theoretical side. When you mention about independence of judiciary, it doesn't mean that there is the House of Representatives cannot give their appointment judges. Yeah, many of countries has used this forum, this institution, because they are legitimate to do that. In Constitution, we also have a high respect in the legislature, in the House of Representatives. So basically, they're doing their job. They have their political interests, and that's who they are. And then if you say the characteristic of the DPR is very political, yes, because they consist of political parties. So of course they are political. So if you want to ask DPR, please don't be very political, they are so political. And then the question would be, why it's happened today? Why not in a long time ago? You need to answer that, because the reality is happened today and not in the last 5 years and in the last 10 years. What happened in the parliament? What their motives? And then how that decision come, and who become the initiator, and then why people agree in the DPR, even though in DPR also there's majoritarian and then also opposition and such and such. For those kind of framework and background will create understanding why this anomaly happens today, and then what their motives, and such and such. And then the question about the theoretical background also have very little, I think, about the theoretical. And then the second you mentioned about Universal Declaration of Human Rights. Even though there is a lot of international and convention that speak about the judicial independence, such as like what we will learn about the Universal Declaration of Independence Justice in Montreal, the Mons Scopus International Standard, Bangalore Principle, and many of them. And then the question would be, what is the difference between the political recall and also the impeachment? Because in many of countries, there's also a process of impeachment, and then it's very different than recall. You need to make it clear. Sometimes the applicant also a House of Representatives in terms of impeachment, and sometimes the House of Representatives or the Parliament also involved in impeachment as a parties to impeach even though a president or maybe a judges. So I don't think this paper has a clarity enough and capture a concept of even independence of judiciary, the impeachment, and then the separation of power in terms of House of Representatives and the Parliament is always be political, but what's behind that is also important. And then and if we learn about the constitutional law, and there is always one of the power that cannot be that always needs to be separate from other powers, institution, and it is judicial power. In the presidential system, we can have a separate president from the parliament, but still judicial power is independent and separate from other branch. In the parliamentary system, the executive is come from the parliament, because the prime minister is come from the parliament. So even though the executive and the parliament can be fusing sometimes, but still, if in parliamentary system and the presidential system, independence of judiciary still outside from other branches. So that principle is applied in even though presidential or parliamentary system. I don't think like this. I don't think you need to work hard for this kind of issues. But my hope for this paper is to get a balanced taste on what's really happened. Because even though the House of Representatives taking over, there are 3 judges. They always still have 6 other judges from other branch. I think that's all from me. Good luck. Thank you very much.
Thank you very much, Ibu Dr. Kurota Ayuni. And we give the author 5 minutes to respond. Please, the author. Yeah, you please use the microphone. You can directly respond to the reviewers.
Thank you very much for the reviewers. There are many notes that I get in this paper. The first note is about from the first reviewer, Pak Ibnu Sina, Mr. Ibnu Sina Chandranegara. We are honored to get you as a reviewer or in our paper. The first question is about the different terminology about ascendancy, and in other terminology we are using intervention. Maybe we need, I think maybe this is some problem in also especially in if we see in the terminology, but we create this paper based on the Prof. Aswanto case, and we see it's also related to the intervention of the DPR, especially because the regulation of constitutional court doesn't regulate the whole DPR can recall the judge. But in the other hand, when we compare in the several developed countries, we find the term about the ascendancy. Like you said before, this term is we find when we analyze the relation about legislative power behind the judiciary power. So maybe we will make a good again in the second in the next writing of this paper about how we can make this 2 terminology about ascendancy and intervention in one way, in one perspective. And the second is about why impeachment is not a recall mechanism. The first we want to say that because this case is still happen, there is not until today there is no solution. When we analyze some opinions say this is a recall mechanism, but in other papers we see this is it's also like some impeachment. So we are very gratitude to get this point, because we will apply in the paper for the next revision why we need to revise about the impeachment to recall mechanism, because we see in the regulation of constitutional court it doesn't regulate about the recall mechanism, but in the fact DPR make a conflict to try to recall the judge. At the same time, we because this is still not regulates the recall, so we say this is maybe some like the impeachment process. This is is still tried by the DPR to Constitutional Court, the judge of Constitutional Court. But in the next revision, we will apply as a note to make a perspective of impeachment is different with a recall. And the next note is about what is the significant impact in this comparative study. It will be maybe answered with my friends, Muhammad Arif Agus. Maybe you can handle this question.
Okay, so what is our aim in the very first beginning to compare from Indonesia and the other countries, especially developed countries? We need to see if there is any case behind in the past of developed countries. We can make apple to apple comparison between what happened in Indonesia and what happened in developed countries. And also we also hopefully can get any solution for the future of the Constitutional Court regulations, because of we need to secure the independency of the Constitutional Court. So we need to think about how the development of the regulations to protect the independency of the judicial power, and also why we need to know that the 6 aspects that we present will open our mind or our view that in the future we know that DPR has a power to change the regulations. So if we want to measure what is the measure of the significant role of the DPR, is this 6 aspect of the Constitutional Court. So if in the future there will be a configuration from DPR by the legislation product, it will be easy to us. This paper will be one of literature that will be explain about how the DPR will be possibly intervene in the Constitutional Court. Thank you.
Okay, thank you very much your answer. The next, I will try to make the analysis about our papers, especially to answer the note from Pak Ibnu Sina Chandrajanegara. We know that we still need more comparison, need more research, especially that you say there are jumping conclusion. We also know that, but because when we analyze this, there is some even also that the case still held. So it is also just we want to just give a recommendation in the future. The output that we want to get on this paper is we just analyze what is the 6 aspect that maybe in the future will become the way for DPR to intervene the Constitutional Court, because we know that the DPR is a legislature power. So there is a wide door to DPR use their power to regulate the constitutional regulation. So in the future, maybe we need some limitation by DPR to regulate the Constitutional Court regulation. Especially with these limits, maybe we can use these 6 aspects that we have analyzed is also compared with developed countries. And the next, we also try to answer Ibu Kurata Ayuni notes how to solve this problem. For Prof. Aswanto, we know that today is still, there is not, maybe we can say this is a block condition, but it's not mean this cannot be solved. The point that we need more active to solve this problem, I think, because the ball in president, so the president must go also to respond this case, especially because if we see the legal norm, there is no way DPR to recall the Prof. Aswanto. But so because that you say this is just a political attraction, so it also can be solved by political attraction by the president as a chief of this country. So maybe the president need to communicate with DPR and also constitutional court, because in the formal regulation there is no way to recall Prof. Aswanto. And the next is about we know that very little about international research, especially we just use Duham. Maybe we will also impute a new international convention about independence of judicial court, and also we need a note. We get a note about why just DPR there, because there is another institution, Mahkamah Agung, Supreme Court, and also President as executive. We say DPR. We analysis more about DPR because we know DPR is based on political party, and the political party have their how to say kepentingan. So this is maybe when they get authority to regulate about the constitutional court. It's maybe there is a wide way for them to intervene the independence of judiciary principle. So especially also that we want to conclude this at this paper that the solution maybe we need more about the limitation by DPR to regulate about the constitutional court, because if this open too wide, there is some potential problem in the future, especially maybe today we just propose the constitutional court, but in the future we know DPR with the president can regulate another intervention, especially that you say in the fourth amendment there is a recall mechanism. Maybe we also more detail about to analyze also this issue, especially to make the DPR with the constitutional court have a good check and balances, no intervention. Because in the first analysis of our article, we conclude that check and balances also needs judge work independently. So there is no problem with this two principle, but how do we manage these two principles in our regulation? We know that DPR have the power, but we also still want to control the power to honor in the independence of judicial. Maybe that's my answer.
Yeah, thank you so much for the authors for paper number 3, Mr. Arif and Mr. Arif and Mr. Irfan. Okay, so and also I also thank you to the reviewers, Ibu Kurota Ayuni and Bapak Dr. Ibnu Sina. So we move to another session. Please, the author, you may leave the table. Yeah, before we jump into the fourth paper, the last papers, I would like to be back to the second paper because the second reviewer for the paper just arrived, just joined with us in this forum. So I welcome the second reviewer. We have Ibu Dr. Yeti Komalasari Dewi as a reviewer to give the suggestion and the commentaries for the second paper.
Thank you. 10 menit. Okay, 10 minutes. Okay, I was asked to review this paper, last night, and to be honest, I just read it, yeah, because as you know that I'm becoming the moderator as well as trying to prepare my presentations. Okay, liability rules practices amidst the property rule of Indonesian capital market. Okay. To be honest, I'm asking the committee, what is the purpose of this colloquium? So basically, we have to provide as honest as possible, yeah, to make this paper to meet the standard of at least ILREF, yeah, Ibu Ririn, yeah, because ILREF is also a standard of international publications. That's why when taking my review, yeah, without offense, yeah. Okay, first of all, when I read this, I try to understand. Yeah, I try to understand what is the legal problem, what is the research questions, yeah, that you need to address. Okay, yeah, in the abstract, yeah, you mentioned about the information, the importance of having these informations, yeah, meaning we know that in the capital market it is transparency, it is disclosure, yeah, particularly in the material transactions, also as well as the conflict of interest transactions, right? But to be honest, then I cannot relate this with the property, with the liability rule and the property rule, yeah, and the property rule, yeah. So that is one. I try to. It is difficult for me to try to understand what is your point, yeah, in this paper. So perhaps you need to again refocusing, yeah, and directly address what is the questions. Now, okay, we move to the background then, the introductions, okay. And then I read your paper until the end, yeah, of the paper of the manuscript. Then I found out that you provided at least 7 or 9 cases. Okay, so for me, yeah, because then basically you are evaluating, yeah, kan, the Bapepam rules, yeah, or the OJK rules, yeah, okay. And then you would like to say that, okay, when the OJK still apply this rule, yeah, kan, in these cases, right, in 7 or 9 cases, yeah. For me, this is basically your trigger, this because of these cases, yeah, you would like to, yeah, write this issue. So basically, yeah, you have to, yeah, at least, yeah, to take 2 or 3 recent cases, yeah, in order to justify your, yeah, research that this is still apply, yeah, because previously we have like the year is 2000, right? So it's like you say 14 years, 15 years ago, yeah. So but this, yeah, this still apply. And what is the problem then if these rules still apply? Yeah, so that is what is missed, yeah, in the background, in the background, yeah, in the introduction. So yeah, perhaps you would like to, yeah, again rethinking how to rewrite or to sequence, yeah, your explanations. Okay, the second part would be, okay, you mentioned this one, yeah. So you mentioned, for me it is important, yeah, important keywords, yeah, and you need to address it, like, yeah, when we talk about dispersed, yeah, dispersed shareholder structure, concentrated, yeah, shareholder structure, yeah, V mestinya gitu ya, you should also explain with the dispersed shareholder structure. Okay, now, and that should be in your literature review, yeah. So in your literature review, yeah, you should, yeah, explain not about this. Okay, page 4, yeah. Literature review, you begin with Indonesia is one of the countries with growing, developing capital market and blah blah blah. For me, this supposed to go in background, because you want to show us that capital market is important. Capital market is developing. Yeah. So the problem, in the capital market will create another problem. For example, economic and so on. So this has to go in background. Yeah. Now the literature review should explain what is the developing issue or framework of concentrated ownership structures, dispersed ownership structures, because this is of the company, of course, what is the property rule, what is the liability rule, what is the conflict of interest, so you mention it, you explain it, but sometimes in the footnotes, sometimes in the footnote I saw it, sometimes in the footnotes, so this is important, to provide a context, for the audience, okay. And with that also I would like to mention about, be very careful again when we talk about comparative with common law system, and Indonesia is a civil law system, okay. Corporation law or corporate law or company law in United States mostly influenced by the theory of economic analysis of economic analysis of law, mostly corporate law, company law in United States, okay, influenced by this kind of paradigm, or philosophy, why? Because they talk about efficiency, mengenai efficiency, okay. So now be very careful, in trying to adopt or to trying to explain what happened in United States, in Indonesia context. Even though we know that Indonesian company law as well as Indonesian capital market law, were influenced by United States, which is common law system. But the way you explain it, have to be very correct, so people will not misunderstood this, okay. Now that is the substance. Also, okay, in terms of, okay, and then I think you also know this, but just to remind you, you need to be very clear, what is the difference between investor type and the shareholders, in the capital market, so both are in shareholders, but for to some extent there is a slightly, or there is differences between investor and shareholders even in the capital market, so investors only, the purpose is only to have a short gain, for the buying or selling the shares, but the shareholders, the pure or the true shareholders is what, is the one that has the lasting interest, right, of the company, so this is different purpose, so you need to be very careful in trying to explain it, okay. And then in terms of the structure, again perhaps you need to try. What is your purpose of writing one paragraph, because then the next paragraph will justify it, so what I'm trying to say is that try to be more consistent, try to be more coherent, try to be more systematic, okay. And for the technical issue, okay, I don't know whether it is already been mentioned, but this is also applied because for my not only for the PhD student, but also for the undergraduate students, when you are using the reference, the references, so you need to you need to make sure that you use the recent or updated references. So if you talk about journal, publications, you can only, for the, if I'm not mistaken, for the international standard, you can only use at least 7 years, period. So if it is going to be published in 2022, let's say, or 2023, then you have to at least to use 2015, right? So before that, okay, you have to find another new publications. Even for the textbook, the textbook, you try to find the newest publications, because if the textbook is the textbook that people look at that textbook, then the company would try to have a new publications. So you need to find the recent one for the reference. And then again, some of the I've already put some of my comments okay, in writing. And again, some there is so many places in your writing, in your manuscript, that you don't provide footnote or reference or justifications. So you cannot do that. For the international standard. Okay. And then also small, but it is important, the consistency of using the legal terminology, or sometimes not only legal terminology, but also sometimes the abbreviations. Whether you would like to use FSA, Financial Service Authority, first and then OJK, or whether you would like to use OJK first and then FSA. It is up to you, but be consistent. Okay. I think that is what else? Okay, updated FSM. Okay. I think let me see. When you look at my notes and your manuscripts, when I bold it in the, for example, in the footnote, it means that it should be because if it is important, then it should be in the body, body text. Okay. Now, for examples, the paper highlights the paradigm of regulations on conflict of interest transactions in the Indonesian capital market and its enforcement. No justification. The choice of those issues as the main theme of this paper is based on two reasons. First, the Indonesian capital market has been running for almost 44 years since it was reactivated in 1977. No justification, no reference. You're supposed to have the reference in here. The ups and downs of the Indonesian capital market cannot be separate from blah 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 blah. No reference. So that's only some of the examples. I think because we are running out of time. Okay. 1 minute. Okay. So look at your page 10. For examples. You explain the dispersed ownership model is characterized by a strong security market and so on blah blah blah. This is supposed to be in literature review. In my opinion. Because this is important. How you explain to the audience what is the fundamental differences in shareholding in the closed company and in capital market in the public company. And then there is sentences that I block in the blue one. So this is what I meant with there is no footnote in this one. Okay. I think that's all for me. And I'm going to give you the written comments. Thank you.
Thank you so much for Ibu Dr. Yeti Komalasari Dewi, our honorable reviewer for the second paper. So I give 5 minutes for the author to respond or ask other question to the reviewers, please.
Thank you very much. First of all, I would like to thank you very much for the precious comment from Ibu Yeti. I think I have to reorganize my paper and focusing on the concept, the legal issue, and I have many notes from you. Then I will use it to improve my to improve my paper. And I just want to say that I would like to see the consistency of the law enforcement according to OJK or Bapepam about conflict of interest transaction. Then I found that every year there is always conflict of interest transaction done by the company, listed company. It's mean I think that how can be it happen in several years from years to years, but the most the rule is every transaction, every conflict of interest transaction, it should be approved by the independent shareholders. But for the several cases, this transaction is done without independent shareholders approval. And then OJK or Bapepam, formerly Bapepam, give the administrative sanction to the company. It means it was a detrimental aspect for the company. So I think why the shareholders, independent shareholders, cannot protect their interests. And this is my concern to write my paper, this paper. That's all. Thank you very much. Thank you.
If that is your aim, yeah, if that is your aim, so you just direct it, say it, yeah, write it, yeah, because we cannot. It's only just, yeah, I only saw it in the background, yeah, but then you go around, show it liability and so on, yeah. So if you would like to focus on that issue, is, yeah, you just direct it, yeah, say it directly, yeah, okay, and then how you would like to relate it, yeah, to the recent situations, then perhaps you would need to again, yeah, justify it with several cases. Yeah. That's all, yeah, okay, and I'm willing to you know to have a discussion further, yeah, for this. Yeah. Thank you.
So once again, thank you so much for the insight from Ibu Dr. Yeti Komalasari Dewi, and also the authors, Bapak Adi Warman, that has participated today. Okay, so we have the fourth paper. This is the last paper for today's forum. The fourth paper has titled an analytical, the fourth paper has titled Human Rights, Peace and Women in Conflict. The paper is written by Bidya Laksmi Salam from Mahidol University. The author is joining online, and after the authors have presentation for 15 minutes, we will have the reviewers. There are Dr. Patricia Rinwinigati and Bapak Hadi Rahmat Purnama. So first, please, Mrs. Bidya Laksmi Salam from Mahidol University. 15 minutes is yours.
Hello, can you hear me?
Yes, clearly.
Yes, thank you very much. I would like to share my screen. Could the host please allow? I am unable to share my screen.
Okay,
May
wait a
I just
minute.
proceed as I have only 15 minutes?
Yeah, it's okay. Okay, please, you can start the share screen now.
Okay. Good afternoon, everyone. Thank you. I would like to give an overview of the context of the paper. The paper is part of my ongoing and to be completed soon PhD dissertation entitled Women's Grassroots Movement in India's Eastern Periphery in Manipur. So the region in the Eastern Periphery neighboring to Myanmar, Bangladesh and Bhutan and China in India has been undergoing protracted low-intensity armed conflict for over 5 decades. There are self-determination movement and in the nature of secessionist militants or revolutionary types, which are often having ethno-nationalist character in nature. And in this conflict situation, what the people and the non-state parties have been witnessing is the state's militaristic approach. When I say militaristic approach, there are several acts and legislations that are criminalizing any militant activity, and one of the main that has been denounced by human rights activists in the region, nationally and also international, is the Armed Forces Special Powers Act 1958, which has its legacy during the colonial period to suppress people's movement against independence, which is still implemented in this region I am talking about. And in the conflict, what people have also witnessed is when human rights are violated, women have been the most affected as survivors, or also when many people are killed, which are mostly men as compared to women, they remain as a survivor and breadwinner of the family also. And here I would like to highlight in the paper is rape and sexual violence that has been used as political weapon, which I try to link, maybe as yet in the current paper, it is not reflected, but in the process I would like to highlight is why rape as a political weapon also is used in the context that I am talking specifically, as this is also a clash or confrontation of two nationalisms. Whereas we have the mainstream Indian nationalism, which is also time and again conflicted with the Indian state, trying to represent Indian nationalism in the peripheral states where there is conflict, versus the localized conflict where the militant groups or even civil society, largely they are working in the paradigm of revivalism, of distinct culture, and the sub-factors. Okay, coming to the point here, what there is a white people's resistance movement of the civilian population in which women are in the forefront, and the Maira Baby movement. My research and also the paper highlights this unique phenomenon of women's movement in Manipur. It is a unique phenomenon because it is solely of women and of large participation by women, and also by now a cultural phenomenon where every household, a participant or a member, women, has to be a member of this. It emerged in the early 1980s when it was the peak of violations and also the enforcement of the said law. So women take to the streets, they vigil their localities in the night to protect people from state atrocities. So it was a sporadic women's mobilization and the collectivity, but over the period what we have seen is getting more and more organized in themselves. So the question here is, because of this, in the militarized patriarchal society, what we have seen is this very powerful women in the front line, and on the other side, the socio-cultural forces that keeps women subordinated. So we have seen a trend in the literature of women in Manipur that either they are empowered or marginalized, which is, there is a gap then. So the paper proceeded in trying to understand this gap. It locates, coming to the framework and methodology of the paper, it situates this context of the Maira Paibi movement in Manipur within the larger frame of the debate of women in this nature of movement, where there is an ethno-nationalist character, because this is the context where they are also playing their politics. And we find this in the contemporary, mostly in the post-colonial or colonized societies. It is a grounded qualitative research where I put the subjective experiences of the movement participants primarily in the focal point. It started with, in the initial, it started with speaking to the prominent activities who are at the state level, higher level, and also the leaders. It went on to becoming a thematic sampling. Thematic by it means where there were more issues or overlapping issues were coming up. When I highlight that, then I approach participants relating to that specific area of the question. I conducted in-depth interview, focus group discussions, and participatory observations widely. Besides that, I also, the data were collected from a wide range of stakeholders who come in contact with the movement. Because they are not working in isolation, there is a vast array of civil society presence, and mostly dominated by male members. Peace building, in terms of peace building, so the movement, besides being themselves victims and also survivors of the conflict, they are also healers, mediators, and also they have provided a sense of comfort and security among the masses. And one very prominent incident of state atrocities where a woman was not only raped and killed, also the brutalness in the way she was killed after being raped by security forces. 12 women in 2004, they held a naked protest. Here the significance I try to highlight in the paper, that such a mode and tactic of women's protest by the Maira Paibi movement, it did work, which may not be in the case of male civil society groups or even feminist groups. Because since then the state, which I also want to highlight in the paper, is that speaking to a gendered state, they respond to the gendered language of the protests, because right after that there were immediate actions taken by the state. Definitely the perpetrators being in the armed forces, where the said law protects them, they have immunity over any sort of human rights violations. Even the right to life is not assured. So in this context that hasn't been changed, but the state also navigates way. Because since then, women's Maira Paibi movement and their protest, there has been a change in the state's approach towards conflict, where the hard approach is now mixed with a soft approach. And in the peace talk, when we are talking about peace building, here I would want to emphasize that peace building that we know normally, or peace talk, that is very rare, and especially in the context of Maira Paibi movement and Manipur state, it is not ongoing. Because the state, the Indian state also has different strategies to deal with different states in conflict, where in some states we see that there are peace talks going on, which is not in the case of currently in Manipur and in the case of Maira Paibi movement. So that is aside. Here we see, in terms of peace talk or peace building, in the social or in the locality level, where they have a lot of power to deal with their communities, and on the other side, with their protests and demonstrations coming in interaction with the state authorities and other civil society bodies. In here, we have seen a high level of where they are being sidelined. So here, the study and the paper, I want to emphasize that women are aware that they are being sidelined and they do not want to be. So first, it was that women are being sidelined from decision making. One step ahead is that women who we are talking about, they do know about themselves being sidelined, and they do not want that. They want to be included in also the decision-making process of any protests or demonstrations that they go through. Here they have been negotiating with state parties and also civil society, with whom they are in parallel working against state atrocities. So decision-making or sidelining from higher level participation is not coming only from the state side, but also from within their own network. And this may be recent, especially with coming of many factors, but they have been doing this already in their household, where their active participations or in public domain was required. They had been negotiating that, often being a patriarchal society, through deception, through manipulations. So it is found that in the case of Manipur and women here to be politically up in the front line, they have to constantly negotiate, work, or do work on themselves, work by themselves, to be able to be unable to do their household duties as well as in the public. And at times when required, the resource they resort to are through deception, manipulation, sometimes even lies. Here it is found that women's mobilization and activism on gendered identity, because the Maira Paibis are the movement which is coming out, is mobilized on the identity of motherhood. And here the motherhood often we have being branded as essentializing women's identity. But here political motherhood, women, they know it. And the reason that they rely on the gendered identity is because this has been the most effective also, given the context, unlike other groups, primarily the rights-based. So the immediate result that they would want, this identity, gendered identity, has been the most effective. And as I said before, because they are speaking to gendered structures and systems who respond to these identities of women. And here what we have seen is also transformation from within the context. Yes, they are not challenging the patriarchal structures directly. They are conforming, but they are also changing, but from within. Because we have seen gender role changes, but not necessarily power relations in gender, definitely. But it has been slow and up and down. It is not one unilateral, one direction. Sometimes it is regressive, sometimes it is transformatory. And the changes have been at the collective level, and also at the individual level. So this sense of women growing their empowerment for personal advancement and also as a collective of the movement, besides the larger state level, the political activism is what I would want to highlight in the paper.
Okay.
Thank you.
Yeah. Thank you, Miss Laxmi. So, yeah, that's a very comprehensive presentation. And now, let us to welcome our reviewers. We have Ibu Dr. Patricia Rinwigati and Bapak Hadi Rahmat Purnama, SHLLM. So, for the first reviewer, Bapak Hadi Rahmat Purnama, the floor is yours.
Thank you. Laxmi, how are you?
I'm good, Hadi. Thank you so much.
Okay, nice to see you again. I have couples, maybe like 3 points that might improve your articles here. I think it started, your articles started very good in terms of, you mentioned especially in abstracts what you are going to do in these articles. And then you mentioned about the analysis that you are going to put or you are going to use in these articles. I have, but what in your article and what you are presenting, it's a little bit different. Maybe you already kind of like polishing the articles as in your presentations, other than the one that I'm all read, that I already read. So my suggestion is that you might need to put what is the questions at the beginning or of your at the introductions of your articles. I mean, you have to put like what, so the reader can understand, or the reader can know what is your articles going to talk about. So at the beginning, at the introductions, when you mention about human rights, peace and conflict, a theoretical framework, maybe you can start with the introduction first about what are the situations, and then you went into the theoretical framework after that. So in that introduction, you might mentions or make a statement about what is the article going to analyze and what kind of questions that you put forward in these articles. So I saw it in your abstract, but I didn't see that in the body of the articles. And then the second one, I think you need to have to, I think you need to put more on the, for example, like what kind of approach you are going to use in this article. It might base on the practices, or it might base on the theoretical. For example, maybe you might use a feminist approach, or you might use other approach that might be help the reader to understand what's going on. Because in terms of the issues that you put in this article, it's very interesting. Because not many people really know what happens in Manipur, right? That's one. And then the second one is the how this impact of the violations and then also the armed conflicts, the impact of the violation and armed conflicts to the way of the women's life in the Manipur. I think that will be very interesting issues that you can share to the bigger audience as with this articles. And then the final one, you might need to put more analytical in your articles. So you might need to put what approach or what theoretical framework that you use, and you need to give more analytical explanations or elaborations as the one that you already mentioned actually in your presentations. I think you need to put that and more elaborated in this article, especially in the third part of your articles. And because I found the issue is very interesting, especially it's very informative for me. However, it's too much of descriptive other than analyticals, because I think it's better to give more. I mean, descriptions is it's very important in terms of giving the background and giving what kind of situations that happens that you will analyze. But analytical, the analysis is also very important for us to understand what happens and how this might, the violations and then the conflict might impact the women, especially in this area, and how the women try to fight back, yeah, on these situations. I think that's, and then the conclusions might follow the analytical that you will use or you elaborate it in this article. I think the conclusions might change during your research, and then I think several points that you mentioned in your presentations, it could become conclusions of your articles. And then it's a little bit, the last one is about the footnote. I think some of the footnote is not yet complete. So I think, yeah, for me, it's a good issues that need to be to be written and to be put it in I think in the journal. And then if you can make the revisions, I think it would be better, and it would be good not only for you but also for the journal. I think that's my last point. Thank you very much.
Yeah, thank you so much for your insightful feedback from Bapak Hadi Rahmat Purnama, and we jump into the second reviewer, Ibu Dr. Patricia Rewindigati. The floor is yours.
Hi, Lasmi. How are you doing?
Hello, Patricia. I'm good, Patricia.
It's been a while. Well, we're supposed to have a meeting, yeah.
Yes.
Let's see.
You're right.
You know, after the departure of, Pong. Anyway, so thank you so much for submitting your paper actually to ILREF. We are very happy actually to have you on board. It's just
Thank
a couple.
you very much. Yes.
Yeah, it's just a couple points. Hadi already highlighted several. So I started actually with the structures, because the ILREF has specific structures. So probably you can actually go to the ILREF and then adjust the structure there. You know, I think that will be probably a good idea. Just as Hadi already highlighted with the introductions, you also have a stories basically, you know, on the back here and there. Probably that's something that we can highlight it in the beginning, and then what is actually the underlining points of that stories basically. And then what kind of theoretical framework that is basically will be used. And then the second point is basically, that's the structures, probably you think you need to look at it. And then the second point is basically about the questions. Usually in the, I know that you're very knowledgeable basically when it comes to human rights, peace, and conflict, especially in the case of the Myanmar. That's in the border. What is it? Manipur, in the India, and then it's in between. Basically, it's just what I see in this paper is basically you try to put everything inside, so it kind of lose focus. So what I suggest is basically because it's just everywhere there. Like for example, you want to highlight the conflict. You want to highlight the feminism there. Although I understand you want to marry these two, right? The feminism within actually the conflict resolutions or something. So I think my suggestion is actually, because this is journal, this is not your dissertations, definitely. Journal is just one issues that want to be tackled, and that's it. I think it would be good. Like this one, I could say it going to be like 3 articles actually from this one. I think you already have the materials basically for writing 3 articles because it's already there. So probably you can even highlight only one. Like for example about like the state of Manipur or the women, the feminisms in the conflict, using the perspective from your one of the stories or the 3 of your stories, for examples, or you want to have the militarizations in Manipur. That's also, it can be actually one topic itself. So I think what I found actually in this article is basically is like a summary of several, in synthesis of several articles basically. So probably you need basically to depend into one questions only, and then to make it focus and more in depth, with the discussions. I think that's probably, and also the way it was written. Usually in ILREF we don't use the like a boxes, I like the boxes. So just look at on ILREF. It's just the structures basically, and how to simplify everything into like very specific questions that you want to highlight. I think in order basically to be instead of this is like a conclusion or synthesis of several theses. Like articles. It's really good for making a book. Actually, it's book chapters. It's like here and there, but we are just only one article. So I think that will be basically restructuring and also focusing on certain issues. I think that's for me basically. Joel also, please, if you want.
No. Are we closing it?
Not. Okay.
Okay, thank you for Ibu Patricia Rinwigati for your reviews, and for the authors, Ms. Laxmi, you have 5 minutes to respond the reviewers, please.
Thank you, Hadi and Patricia. I cannot agree more actually. And thank you very much for reading the paper very, very carefully. I see my point here and there, it's been brought out. I agree totally that, from the manuscript that I submitted and to the presentation, there is a step, I would call it forward, that already I'm restructuring in the presentation. So, yes, that has been there, and I understand there is scope for at least there is a process of revision with the review from you all. So, and that follows with that jump and the current standard of the manuscript, I accept all this, actually, the comments, especially coming from the structure and question, these two. they are related also to narrow it down, because one point in my the end slide that I have put, the conclusion, they are quite already big, you know, conclusions, 3 or 4, and I can pick one of them. If they may come under the subcategory of that can be dealt with, that I will have to deal with it, but highlighting only one aspect, one specific point, and deepening the paper engagement on that. So yes, I do agree with the comments, and I'm very thankful to have the comments now. I can see right in front of me written down, and I will work on it. Thank you very much.
Thank you very much, Lakshmi, for...
Thank you, John.
Thank you very much. So now we have reached the end of our... Have we reached the end? Yeah. We've now reached the end of our colloquium, of our writing colloquium. I hope this... Again, I think the whole point of this writing colloquium is to normalize this peer review process, to solidify academic camaraderie. And again, I think we were successful at doing that, no? Indeed. So, all right. Again, we'd like to thank our, first and foremost, we'd like to thank our authors. Yes. So before we end, we would like to take a photo with our authors and everyone who is here. All right? Yes. So it's a full house. And we'd like to take a photo for everyone so that we have a memory of this monumental event. So may I ask everyone to please come in front? We'll do a hybrid photo. Yes. Oh, yeah. May we ask also our technician to put up everyone on screen? May we ask our, who is he? All right. 1, 2. One more? One more?
Oh iya mas, ya mas. Mas Arif. Ya. Mas Arif. Ya. Ya. Apa ini? Cuan. Cuan dong, gue.
Lagi. 1.
To Mas Arif, please turn on your camera. Mas Arif, please turn your camera on.
Okay, makasih. Thank
so
you very
much.
much. Thank you very much for giving your time. We hope to see you again. Hope to see you in person. Okay, on behalf of my colleague, okay.
Yeah, thank you for my colleague, Joel Barredo. Yeah, okay. Yeah, thank you so much for all the participants, the presenters, the reviewers. We give most gratitude for your participation, and hopefully we can meet in person for another event conducted by Joko Sutono Research Center and Faculty of Law Universitas Indonesia. Thank you.